on order case item number 7, there is a fixed matter at 215. If that is taken, order case item number 7.
So,
If that is taken, because there is a fixed case for hearing.
yes.
250.
What is that orders case for?
No, notices were issued. Now the report has come. Only notice is to be accepted.
Like the serial number 7. Nobody has appeared for the respondent?
No, respondent, no one. 410 it was served upon them, but till date they are not.
देखिए first appeal number 175 of 2024. Counsel for the appellant submits that the notice has been served upon respondent number 1 personally, and so far as respondent number 2 is concerned, it has been served through her husband.
So one it has been served through wife, and 2 is the wife. One is husband is 1.
Okay. Notice has been served upon respondent number 1 personally, and so far as respondent number 2 is concerned, the same has been served through her husband.
So it is other way around.
This
Wife has received notice on behalf.
the respondent number 1 has received notice
No,
on behalf.
respondent number 2 has received personally notice, and on behalf of her husband, respondent number 1. Wife has received notice.
Respondent number 1 का दिखा रहा है notice served through personally, और respondent number 2 का दिखा रहा है
हमको पढ़ने में
कुछ भी बोलते एकदम unnecessary.
हमको सर, आई एम सॉरी, हमको समझने में
Notice has been served
I have gone through it.
her husband.
I'm sorry.
He submits that the notice may be accepted as validly served. Considering the circumstance above submissions, the notice upon respondent number 1 and 2 is accepted as validly served. क्या matter है?
The first appeal partition का था. Partition suit has been dismissed.
There is no nucleus. There is no nucleus. Separate self-owned property.
It was, मतलब it has come in evidence.
कब करेंगे बताइए? रिकॉर्ड आ गया, करेंगे कब ये बताइए? कब
My
करेंगे?
client is out of India. Let him come.
क्लाइंट से क्या लेना देना है? फर्स्ट अपील का रिकॉर्ड आया, बहस करिए. क्लाइंट का कोई जरूरत नहीं है, पैसा ट्रांसफर हो जाता है ऑनलाइन.
ठीक है.
बताइए कब करेंगे बताइए?
अगला महीना दिया था.
Post this case, the learned counsel has submitted that the partition suit has been dismissed. The records have already been received from the concerned court. Post this case for final disposal on 4th of February.
On
4th February. To be taken up at 2:15. 2:15 बजे होगा सर. 2:15.
Please clear item 14, second appeal 431 of 118.
Before madam enters into
Time
date.
नहीं देंगे.
No time. My lord has fixed it at 2:15. How can I dare to say that I
नहीं
want
नहीं
time?
ऐसा बात नहीं. Time
There
मत
is no
मांगिए.
reason for time.
Order 7 Rule 11 का केस है आपके पास.
What I am trying to assist your lordship on the matter, my lord, that they have filed a stay application, my lord.
स्टे नहीं सुन रहे हैं.
हम खाली हुजूर को बता रहे हैं. The stay application is there, and in reply to the stay application, we have filed our reply to the that IE application. My lord will just have a look to that reply. We have brought before Lordship Matter for my lord's kind consideration. The appellant before Lordship is such a person who has no care of this system of law. They have lost the decrees against them, and during pendency, they are praying for a stay of the decree and judgment. They are selling the property.
कुछ नहीं अभी सुनेंगे ना अभी
Continuously.
देखिए
And I
हमारे
have
पास
no-
ये क्या है
I
सेकंड
know, my
अपील है
lord. I have been
Right.
informed by my
उसके
junior
बियॉन्ड
colleague.
हमको रिकॉर्ड के बाहर हम कुछ नहीं सुनने वाले हैं.
नहीं, हम ब्रॉड रिकॉर्ड में लाए इसीलिए उसको।
कोई इससे फर्क नहीं
कि
पड़ता है.
एक
क्या ही
लाइन
ऐसा
से
है?
7-8 जमीन बेच दी.
अच्छा कोई बात नहीं, जो कुछ भी कर दिए हैं नहीं कर दिए इससे हमको कोई मतलब नहीं है. लिस्ट पेंडेंस का
हम खाली
प्रिंसिपल है ना.
एकदम है.
हाँ, तो
उसमें
बस.
तो अब तो लेटेस्ट सुप्रीम कोर्ट का जजमेंट भी आ गया. मैं खाली हुजूर के नॉलेज में देना चाहते थे कि
नहीं,
यही
ऐसा-
कंडक्ट है इनका.
ऐसा नहीं है. कंडक्ट से केस नहीं डिसाइड
My
होगा,
lord,
केस
my-
रिकॉर्ड से डिसाइड होगा,
That,
है ना.
that's
कंडक्ट बहुत खराब भी हो सकता है,
my lord.
लेकिन रिकॉर्ड में नहीं होगा तो नहीं होगा.
नहीं, हम इसीलिए रिकॉर्ड में भी ला दिए.
चलिए बहस करिए.
My lord, may it please your lordship. My lordship,
यस
before I make my humble submissions, I am submitting a list of additional substantial questions of law, my lord. Fact of the case in gist is,
सर देखिए द सूट हैज बीन डिसमिस्ड बाय
suit has been dismissed on the ground a petition was filed under Order 7 Rule 8.
अब उसमें एडिशनल सब्सटेंशियल क्वेश्चन ऑफ लॉ कैसे ही हम डिसाइड करेंगे?
अच्छा ठीक है,
आप हमको बताइए जब
हजूर
तक सूट
बोलेंगे
में
तब
कोई
तो हम जवाब देंगे.
नहीं आप हमको नहीं एक सिंपल सा बात बताइए. इफ द सूट हैज बीन डिसमिस्ड बाय रेफरिंग टू ऑर्डर 7 रूल 11,
जी,
उसके अलावा हम क्या ही देख सकते हैं यहाँ? कुछ देख
बस.
सकते हैं?
नहीं,
फिर बात खत्म. इसीलिए
बस.
ऑर्डर 7 रूल 11 में कंसाइन
तो,
करिए.
तो यही चीज जो है लोअर अपीलेट कोर्ट ने नहीं अप्रिशिएट किया. उनको रिमांड कर देना था, उन्होंने रिमांड नहीं किया. उन्होंने कहा कि रेस जुडिकेटर नहीं लगेगा. तो
आप इसीलिए जो
एविडेंस लीड करने के लिए मौका दिया होता. लोअर अपीलेट कोर्ट ने, फर्स्ट अपीलेट कोर्ट ने
कोई बात नहीं
भेजा
सर.
नहीं है अंडर ऑर्डर 41 रूल 23, रिमांड नहीं किया. हम
जब पढ़िए.
देख कर लास्ट टाइम जब माय लॉर्ड्स बोले तो हम इसको ट्रायल कोर्ट, लोअर अपीलेट कोर्ट जजमेंट दोनों देखे.
आप
हमको
दिखाइए
लगता है
ना,
कि
दिखाइए.
इसमें एविडेंस की जरूरत है, बिकॉज द
ऑर्डर
क्वेश्चन
7
इज
रूल 11 में एविडेंस की जरूरत नहीं होती.
नहीं उसको नहीं. ऑर्डर 7 रूल 11 का तो इशू ही अब हजूर हम नहीं रेज कर रहे हैं. ऑर्डर 7 रूल 11 का इशू ही नहीं रेज कर रहे हैं, बिकॉज ऑर्डर ये तो रेस जुडिकेटर के ग्राउंड पर सूट को डिसमिस किया गया विदाउट टेकिंग एविडेंस कि व्हाट क्रिएट्स द बार ऑफ रेस जुडिकेटर. लोअर अपीलेट कोर्ट ने, फर्स्ट अपीलेट कोर्ट ने without in absence of any evidence it has decided कि किसमें क्या था किसमें नहीं था, एविडेंस था नहीं था. एविडेंस तो लीड ही नहीं हुआ in respect of the suit properties, and it has written, the first appellate court has written कि दोनों
इसमें सब्सटेंशियल क्वेश्चन ऑफ लॉ नहीं फ्रेम हुआ है.
जी
सब्सटेंशियल क्वेश्चन ऑफ लॉ नहीं फ्रेम हुआ है.
इस केस में नहीं.
हाँ तो जब तक ये सेकेंड अपील है ना,
हाँ,
तो आप ऐसे फ्री स्टाइल तो नहीं चलेगा. पहले सब्सटेंशियल क्वेश्चन ऑफ लॉ बताइए
my
क्या
lord.
है.
Then I will
दोनों जजमेंट्स प्लेस करिए, उसके बाद ही
जी
देखिए.
जी जी.
ट्रायल कोर्ट दिखाइए.
मानो निकाल. My lord, it starts from page number 18. Order is dated 16/3/2013.
ऑर्डर 7 रूल 11 में रिटन स्टेटमेंट देखेंगे कि नहीं, या वो भी नहीं देखेंगे?
Order 7 Rule 11 में पिटीशन पड़ा है बाद में. Suit was of 2009. A written statement was filed. Thereafter, the petition under Order 7 Rule 11 was filed in 2013, and the order has been passed in 2013. The petition was filed on 7th of February 2013. Order has been passed on 16th of March 2013.
Is
May I
there any
please-
law कि रिटन स्टेटमेंट के मतलब बाद नहीं फाइल हो सकता है?
नहीं, हमको नहीं लगता कभी भी फाइल हो सकता है.
ऑर्डर 7 रूल 11
जी.
दिखाई जरा से.
और अब तो हम उसको अब मेरा रिकॉर्ड है, अब तो हम उसको रिलाई भी नहीं कर रहे हैं.
सर ये
ICP
सारा
से-
प्रोसीडिंग रिकॉर्डेड है, इसीलिए ऐसा बोलिए ही मत मैं नॉट रिकॉर्डेड, इट इज ऑलरेडी रिकॉर्डेड.
ठीक, तो इसको हम लेट मी प्लेस इट. मैं
जस्ट
rejection of claim. The claim shall be rejected in following cases. पेज 80 के आसपास. मेरी
दैट्स राइट, इसमें कोई टाइम टेबल नहीं दिया.
नहीं. May I read the judgment? The record is fixed for order.
तो एक सेकेंड,
जी,
आपने
page
सब्सटेंशियल
80.
क्वेश्चन ऑफ लॉ फ्रेम किया होगा ना भाई. अगर आपको रिलीफ देना है तो पहले सब्सटेंशियल क्वेश्चन ऑफ लॉ आप दिखाइए कहाँ पे फ्रेम किया है, देन आई विल सी द जजमेंट.
The issues
द सब्सटेंशियल क्वेश्चन ऑफ
in this case.
यस.
और अपील में
हाँ.
point for determination वो भी नहीं किया है.
पॉइंट फॉर डिटर्मिनेशन नहीं. यहाँ पर सब्सटेंशियल क्वेश्चन ऑफ लॉ आपने क्या फ्रेम किया है?
वो हमने जो दिया है.
हाँ
जी.
यहाँ पर पेज
यहाँ
नंबर
मतलब-
4 में है.
एडिशनल भी हमने दिया है, हम इसी को प्लेस करना चाहते हैं एडिशनल को. इफ आई एम परमिटेड टू प्लेस एडिशनल को काइंडली देखा जाए, रेलेवेंट फॉर द केस ऑन द मेरिट सही हो. May I read, madam? Whether in absence of any evidence, the London First Appellate Court has illegally arrived at a finding that there is violation of compromise decree. And number 2, the schedule A, B, C, D, property of title suit number 61 of 2001, and schedule A, B, C, property of partition suit number 13 of 1995 are defect. क्योंकि records evidence आता तब ना होता है. Next, whether in absence of any pleading in the plaint of title suit number 61 of 2009, there were two partition suits going on. In the first partition suit amongst the brothers and sister of the appellant minor, parties entered into a compromise and they partitioned the property 1/4 each. Now subsequently there is a allegation that as per that compromise decree, the plaintiff of the previous suit did not receive the 1/4 of the property. In fact, she prayed for the property as per the monetary value. And in the subsequent suit ballot which was brought by the person who is challenging the who is making the allegation that he did not receive anything, has not pleaded in the plaint. Number, may I read my lord?
Yes, yes.
The second substantial question of law is whether in absence of any pleading in the plaint of title suit number 61 of 2009, that is the subsequent suit, in absence of breach of compromise decree in partition suit number 18 of 1995, the judgment passed by the learned first appellate court becomes perverse and without any basis, without any evidence. But number 3 is whether the finding given by the learned first appellate court on the merits of the case, in absence of any evidence, makes its judgment and decree perverse and illegal and hence fit to be satisfied.
Just a moment. Mr. Rajesh Kumar, in a case where the suit is held to be barred by not maintainable by virtue of Order 7 Rule 11.
Rule 11.
Trial court said that Order 7 Rule 11 it is not maintainable.
No.
Right? So there is no question of any evidence at that point of time. Appellate court has reversed the decree. Right? Now, if the suit is held to be maintainable, it ought to have been remanded to the court for adjudication,
इतना ही मेरा करना है
and all the points should have been left open.
जी.
Res judicata by itself is a mixed question of fact and law.
Fact and
So all the questions should have been left open.
जी.
बताइए क्या करें हम इसमें? कोई एविडेंस नहीं हुआ रेस जुडिकाटा में क्या है क्या नहीं है, who were parties, what was the decree, what was the nature of regime, what was the pleadings between the parties. These things are required to be examined.
my lord, keep it open,
अब
my
क्या?
lord, for next week, my lord.
अब नेक्स्ट
Only
वीक
on
किस
this
लिए?
point, madam,
नहीं,
because-
ओनली ऑन का यही
My
तो
lord, I
पॉइंट
got
ही
my
है.
lord's mind. I am
नहीं अभी नेक्स्ट वीक
थोड़ा सा खाली इसको सोच के एक बार कंसेंट ले ले पार्टी से भी।
कंसेंट का कोई जरूरत ही नहीं है
इसलिए
ना,
हुजूर
लॉ
की-
का जरूरत है, लॉ के लिए कोई
लॉ को भी एक
कंसेंट
बार देख लेते हैं।
लॉ
Point
के
सही
लिए
है।
आप हमको
हुजूर
बताइए
जो बोल रहे हैं एकदम
ऑर्डर
सही
7 रूल 11 में
सही बात है। जो
बोल दिया
आप
कि
बोल रहे
नॉट
हो सही।
मेंटेनेबल.
खाली
Decree हो गया reverse.
एक चीज सोचने की बात होगी
हाँ.
उसके बाद
हाँ.
कि जो प्रॉपर्टी को सेल कर दिया जिसका डिटेल हम ब्रॉड किए
उससे वो ज्यादा जो भी कुछ होगा आपका सूट में चलेगा.
उसको खाली देखना पड़ेगा।
क्या
उसका
ही
fact
देखेंगे
क्या
हम लोग, हमें से
इसको
इम्प्यून्ड
तो हुजूर
ऑर्डर,
को-
वी आर ओनली कंसर्न विद इम्प्यून्ड ऑर्डर.
उसका
रोज-
इंडिकेशन आ जाना चाहिए हुजूर
नहीं,
की जो
कैसे
बेच
हम
दिए
ऐसा
हैं,
कुछ भी
after
एक शब्द
losing-
नहीं-
after losing in the
एक
decree,
शब्द नहीं बोल सकते हैं
after
जो
losing in the first
we
appeal,
do not know.
they are selling the property
You
and
see,
not only that, my
जो
lord,
इसमें नहीं
they
है
have demolished the entire house.
कर लिए होंगे ना, तो क्या ही करें, आपको जो मर्जी करिए.
हम नहीं किए,
मतलब देखिए ये जो दो
हम तो
ऑर्डर
उसके
है ना,
खिलाफ भी रिट फाइल किए हुए हैं।
एक सेकंड, ये जो दो ऑर्डर है ना,
और आज ही लगा हुआ है रिट भी हुजूर।
ये दोनों ऑर्डर के बियॉन्ड तो हम जान नहीं
हम
सकते.
समझ गए हुजूर का।
बस इतना ही है. वहाँ आप बोलिएगा किसको पार्टी बनाना है, किसको क्या करना है, वो बेच दिए हैं, वो
ठीक
अच्छा
है।
आदमी है नहीं अच्छा
इसको
आदमी है.
इसको कल के दिन
अच्छा ठीक है, कल के लिए रखें.
मैं एक बार
The learned counsel for the parties are present. The learned counsel for the appellant has submitted that the suit was dismissed by referring to Order 7 Rule 11
जी.
and the plaint was rejected. The appellate court has reversed the decree. But while reversing the decree, the appellate court ought to have remanded the matter to the court concerned for decision on the various issues which were already framed after adducing evidence. यही है?
issues were
नहीं,
not-
Issues were
additional
framed.
नहीं फ्रेम हुआ है.
Issue frame.
हाँ, after return statement the issues were framed.
हाँ,
Then
issues
they-
were framed.
they
He has
filed
also submitted
then they
that
filed Order 7 Rule 11.
the petition.
एडिशनल करेंगे तो क्लियर हम भी जवाब देंगे.
He has also submitted that the petition under Order 7 Rule 11 was filed after filing of the written statement and
Yes,
after framing of the
And
issue.
after framing of
The learned counsel has submitted that a substantial question of law arises in this case.
One and four को
Which
कर
is as
देंगे.
follows. Whether the first appellate court, after arriving at a, while reversing the decree, after arriving at a conclusion that the suit was wrongly dismissed by referring to Order 7 Rule 11 of CPC ought to have remanded the matter to the trial court for decision on the various issues framed by the court. That's all. This council, this appeal, he has also submitted that on the face of the orders passed by the learned court, the records may also not be required, and the appeal can be disposed of on the basis of the upon perusal of the impugned orders itself. The learned counsel for the respondent has also submitted that the records may not be required, but he seeks adjournment, and he submits that the matter be posted tomorrow. ठीक है? This appeal will be heard on the aforesaid substantial question of law, as agreed by the parties, and considering the nature of orders involved, this court is not inclined to call for the records from the concerned. ठीक है?
ठीक.
Post tomorrow.
Public person. दही खा के आए तो इसमें मुश्किल हो गया पानी पीते पीते हल्का
Orders item 8, first appeal 209 of 2024.
Issued to whom? बताइए. Which respondent? There are so many respondents. ऑफिस नोट नहीं पढ़े? पढ़ी. मेरा काम नहीं है ऑफिस नोट पढ़ना. दे दीजिए. ये प्रीवियस जो कल गया है ना.
Item 9, first appeal 216 of 2024.
Notice has not been directly served upon respondent 9. I'm praying for not today. But we will file wakalatnama for respondent 1 to 9. So we'll be within 2 or 3 days.
Respond number 1 to 9.
Yes, ma'am.
और 10 तो है ही. State has been served.
Nobody is appearing in worship.
Have you served notice on the state?
Worship has verified.
स्टेट की तरफ से कोई अपीयर ही नहीं हो रहा है. आप उनको भी सर्व कर दीजिए. ठीक है.
Yes, ma'am.
1 to 10 को नोटिस हुआ. Notice served. Already served.
According to the office order, only respondent number 9 was concerned.
You will accept notice on behalf of respondent number 9 also. FA number 216 of 2024. Mr. नाम बताइए.
Sudhanshu Singh.
Sorry.
Sudhanshu Singh.
Sudhanshu Singh. Advocate submits that he has received instruction to appear on behalf of respondent number 1 to 10.
1 to 9 worship.
1 to 9.
We will file the
Your junior
wakalatnama.
counsel to
Rupesh Singh.
associate counsel to Mr. Rupesh Singh. He prays for 2 days time to file wakalatnama. So far as respondent number 10 is concerned, the notice has been served. Record आ गया? Records have already been received from the concerned court. Considering the submissions, no fresh notice is required to be issued to any of the respondents. कब करना है बताइए, क्या मैटर?
Plaintiffs have filed, plaintiff is a company, they have filed suit through the proprietor claiming right and interest in possession of the property and for cancellation of sale deeds of 71. Respondents had appeared, they had supported the
Sale
claim.
deed of 71.
Yes, Your Honor.
अच्छा 1971.
1970. Subsequently, the defendants appeared and they supported the claim of the plaintiff. The claim to be, they were the recorded traders who had accepted to execute the sale deed on behalf of the plaintiff. And the suit was dismissed on the ground that it was in contravention of section 46 of sale deed.
The sale deed was in contravention,
Yes,
so suit must have been decreed.
suit was dismissed. My sale deed was found to be in contravention of section 46.
This case has been formally admitted. कब करेंगे बताइए?
Next week, Lordship.
Lordship, after 4 weeks, we're going to file the wakalatnama.
Post on 11th February.
Also case item 8, first appeal 209 of 2024.
We have a notice under to respondent number 1, 3 to 5, 9 and 10. So it has not been received by the said respondents.
1,
3 to 5,
5,
9 and 10.
9 and 10.
And
Who are you representing?
Ladyship, I am representing respondent number 2.
2. And 6, 7, 8?
No, I am not representing 6. 6, 7, 8 were the defendant. Respondent number 5, 1 to 5 were plaintiffs.
9 and 10, one is received by son, other is received by nephew.
yes, ma'am.
So,
Contact them. Fresh notice.
who is Vinod Kumar Singh? As per the office note, counsel for the party, petitioner, appellant and respondent number 2 are present. As per the office note,
Ladyship, Vinod Kumar Singh is the husband of respondent number 2. He has died, passed away. So thereafter, this suit is filed.
thereafter,
After his death, this present suit is filed. Vinod Kumar Singh happens to be the husband of respondent number 2. He died and thereafter.
and you will not accept notice on behalf of respondent number 3, respondent number 4, respondent number 5.
Ladyship, they have contacted me, but yet they haven't executed wakalatnama on my favor. I'm hopeful that they may, but I'm not very certain about that. Whether they like
And who is respondent number 10? आप अपने बच्चों का भी वकालतनामा नहीं फाइल कर सकते. This is bizarre.
Leadership, they have contacted me. I have sent them wakalatnama, but they haven't executed it as yet.
So will you just seek instructions and file wakalatnama on their behalf?
I'll seek instructions.
The learned counsel for the respondent number 2 has submitted that he shall seek instructions and file wakalatnama on behalf of respondent number 3, 4 and 5, who are the daughters of respondent number 2.
And respondent number 1 also. 1 is the son.
He also submits that respondent number 1 is son of respondent number 2 and he shall seek instructions and file wakalatnama on behalf of respondent number 1 as well. Correct? तो 1 to 5 का तो ये हो गया स्टोरी ओवर. उसके बाद 6, 7, 8, 9. The learned counsel for the petitioner submits that so far as respondent number 6, 7, 8, 9 and 10 are concerned, the same has been received either by themselves or by their close relatives. ठीक है? कोई nephew receive किया in the same case.
By registered post, it has not been served to respondents.
Registered post से क्या मतलब है? जो ordinary process is a better mode of service.
Yes, they have
वो
received.
खुद जाते हैं. She submits that the notice be accepted as validly served. Considering the submissions, the notice upon respondent number 6 to 10 is also accepted as validly served. Okay? Service complete. अब बताइए रिकॉर्ड आ गया? रिकॉर्ड आ गया? रिकॉर्ड आ गया. सेल डीड के वेंडर कौन है? Who is the vendor of the sale deed?
Appealant.
Appealant is the vendor? बताइए कब करना आपको? When do you want to do? When do you want to do? Service is complete? अब एडजर्नमेंट का कहानी खत्म. मेरी तरफ से अब एडजर्नमेंट हो सकता है, आपकी तरफ से नहीं हो सकता. बताइए कब करना है? When do you want to do it?
Leadership, second week of February, if it's convenient.
With the consent of the learned counsel for the parties. नहीं, ऐसा consent मत लिखिएगा. Post this case on 12th of February 25 in the supplementary cause list. Awaiting filing of wakalatnama of respondent number 1, 3 to 5 and other respondents.
Leadership, I have a small prayer. If they may serve a copy of memo of appeal.
दे दीजिए ना.
Yes.
Item 10, first appeal 221 of 2024.
Yes.
Mr. Lordship, will be filing our appearance for respondent number 1.
What about others?
Three and
2, 3, 4. Okay. Respondent number 1 and आप किसकी तरफ से?
1, only 1.
Respondent number 1. 2, 3 and 4. और 5 to 9?
It will not be delivered. And for serial 8, it's saying that it's not tracing the address. Is
नोटिस हुआ है?
हाँ, notice है.
1 to 9.
Five and 6 has received personally. 7 was not found. 8 has received through. Okay, लिखिए. 7 का क्या करना आपको? Not found.
I'll seek instruction from the plaintiff if they have any other address.
FA number 221 of 2024. Mr. Vishal Tiwari accepts notice, submits that he has received instructions to appear on behalf of respondent number 1. Ms. Rashmi Kumar submits that she has received instructions to appear on behalf of respondent number 2, 3 and 4. हो गया? And has already filed वकालत. So far as respondent number 5 and 6, 5, 6, 8 and 9 are concerned, the same has been received, the notice has been received either by themselves or through their close relative. The learned counsel has submitted that, or the appellant has submitted that, the notice be accepted as validly served. Accordingly, notice upon respondent number 5, 6, 8 and 9 is accepted as validly served. ये respondent number 4 का by hanging हुआ है, notice by hanging at the door.
4 is appeared.
अच्छा 4 तो हो गया ना?
2, 3, 4 till 4 log
ठीक है।
appear.
So far as
Only for
respondent number
7.
7 is concerned, the notice has received unserved on account of insufficient address. Counsel for the appellant prays for 2 weeks' time to take fresh steps upon respondent number 7 at his present and correct address, or to file appropriate petition seeking substituted service. Record आ गया? The records have already been received from the concerned court. Pose this case on January 30th in supplementary cause list. आने दीजिए उस दिन, या तो आप अपना you will say that you either you file the requisites or you file interlocutory application.
Madam, can I get one more week?
आपकी जरूरत नहीं है उस दिन, hearing नहीं होगी, उस दिन hearing नहीं होगी. Either they will file a petition for substituted notice, then we will pass an order on that, or present and correct address पे होगा तो notice dispatch करने का order कर देंगे.
Item 11, first appeal Triple 2 of 2024.
Yes.
So I have entered appearance on behalf of the respondent number 9.
Only.
Only respondent.
Okay. What about others? ये भी notice
So
नहीं
this
चलेगा.
report is perhaps awaited lordship for others.
Undelivered registered cover तो आ गया. कुछ का बाकी है.
It was
Mr. Rahul Kumar
Yes.
appears on behalf of respondent number 9 and has submitted that he has filed
Nine.
wakalatnama.
So far 8, 9, 10 are concerned because it was ex parte against the defendants over there also.
उसके लिए तो इनको appropriate steps लेना
That
होगा.
is true. This is a case where 35C of the CPC has been invoked and a compensatory cost has also been imposed. After a pretty long time we have seen such.
The learned counsel for the appellant has submitted that the matter be adjourned as service report with respect to a few respondents is still awaited. Post on 30th in supplementary cause list. नहीं होगा तो फ्रेश स्टेप
हाँ, then fresh will file.
और जो लोग नहीं अपियर हुए हैं उन पे नहीं करना है या जो भी कुछ करना है just
On that day.
आपको उस दिन जो करना है ये फाइल कर दीजिएगा ना एडवांस में.
I'll see.
आप देख लीजिए what is the procedure if they are not appeared there.
If they are not appearing here, it will also proceed ex parte.
I do not know. आप
Yes,
देख
yes.
लीजिए. You have to file appropriate petition to that effect. ऐसे नहीं करेंगे.
That
जब यहाँ से एक बार नोटिस हो चुका है ना तो इस तरह से नहीं करेंगे.
And then I'll file an application.
वो आपको सर्विस कंप्लीट करना ही होगा.
हाँ.
मतलब भले सब्स्टिट्यूटेड सर्विस करना.
But if even after lordship is a valid service of notice, if they are not appearing, then
हाँ, then there is no.
that is what I'm
then
saying.
there is no.
The next date lordship will see
हाँ.
that what is the present status. Thereafter lordship appropriate application.
Yes.
Permission item 12. The rupees 3697 of 2016.
You know, see, earlier petitioner was appointed in Bihar Food and Supply is in erstwhile of Bihar, Your Lordship. The point of consideration is that whether
What about this LP?
it has been disposed of, Your Lordship, and it has been it has been dismissed, Your Lordship. It has been held in NPA, that is, it is not the fresh appointment, Your Lordship, whether it is transfer to deputation, Your Lordship.
Yes. Why was it adjourned on account of pendency of this LP?
Your Lordship, because they have passed the order for extension of benefit of ACP and MAC with the condition that it will be affected by this LPA, Your Lordship. So it was.
And we have also stated in also by supplementary
They have given
para
the.
15 and 16.
So you argue the case.
So, Your Lordship, I am also covered by this judgment, Your Lordship, as I was in part of the CWJC, Your Lordship. For that CWJC, they have preferred the LPA, Your Lordship.
Okay, this CWJC.
Yes, Your Lordship. An extra one, Your Lordship. That was for pension. This is for the ACP, MACP, and they have extended also the benefit, but they have not given the monetary benefit, Your Lordship. Their supplementary counter affidavit in page number 15, Your Lordship.
Let us see your prayer first.
Yes, Your Lordship.
Since it is not a fresh appointment, then under such circumstances that continuity of service is already there. And what about the consequences will follow? MSCP, everything will follow.
Yes, Your Lordship.
I have also stated.
So it can be disposed of in the light of the counter.
And Your Lordship, direction may be given also for the monetary benefit, Your Lordship. That has not.
Where is the supplementary counter?
Counter affidavit.
Dated 31/3/2023, Your Lordship.
Supplementary counter affidavit.
Yes.
Page 15, Your Lordship. That is the order.
18/3/2020.
Place your supplementary counter affidavit. Annexure A is the order, no?
Annexure B, Your Lordship.
Annexure A to the supplementary counter affidavit.
Yes, yes.
I think annexure A ही है.
25/4/23.
576. 576. आपका तो 576 का
There after next page, your lordship. Page 15.
page
15 of their counter, supplementary counter, annexure B, your lordship. That is the order. In that order, they have extended the benefit of SCP and MSCP with the condition.
आप समझ नहीं रहे ये पेज नंबर 7 पढ़िए अपना काउंटर एफिडेविट का that the same may be affected by the final judgment of LPA number such and such. Annexure A कहाँ है? Letter number 576. Where is it?
चलिए पेज
30?
32 में
ये लेटर नंबर 576 है ही नहीं.
नो लेटर नंबर 576 डेटेड
2-3 ना डेट मिल रहा है ना लेटर मिल रहा है. क्या लगाए हैं आप इसमें? ये अक्षर F पेज 39.
इनका में है ये 14 ये वाला है 6-4-23
क्या है 6-4-23?
25-4-23
Supplementary filed on 25th 4/2013.
In supplementary counter affidavit, your lordship, they have.
29-3-23 दिख रहा है. इसके बाद भी फाइल
हाँ इसके बाद ही पेज ये पेज 39
पेज
39
इस सप्लीमेंट्री तुम्हें तो पेज 39 है ही नहीं. ये क्या है? रिजॉइंडर होगा शायद.
सप्लीमेंट्री काउंटर
सप्लीमेंट्री
कॉपी हम सप्लाई किए
भाई ये आपने 31-3-23 को आपने फाइल किया है, सर्व किया है शायद.
39 पेज नंबर.
आपका पेज नंबर भी टैली नहीं करता है क्या? आपने क्या लिखा है पैरा नंबर 7 में बताइए. लेटर नंबर 576 वेयर इज दैट? Annexure A to the supplementary counter affidavit. ये आपका एनेक्शर F दिख रहा है पेज 39 में. एनेक्शर A तो नहीं है
ये रॉन्गली टाइप एनेक्शर A
देखिए. heard the learned counsel appearing on behalf of the parties. This writ petition has been filed for the following relief. The learned counsel for the petitioner, the learned counsel for the respondents has referred to supplementary counter affidavit dated 27/3/2023 and has referred to letter number 576 dated 2/3/2020 to submit that the Joint Secretary Food, Public Distribution and Consumers Affairs Department, Government of Jharkhand has directed that ACP/MSAP may be sanctioned to the petitioner Abu Zafir Ansari, counting the past service rendered by him in Food and Civil Supplies Corporation, with the condition that the same may be affected by the final judgment of LPA number 322 of 2013. He has submitted at this the learned counsel for the the learned counsel has fairly submitted that LPA number 322 of 2013 has been ultimately dismissed. Counsel for the petition submits that there is no impediment in passing appropriate direction with regard to with regard to payment of monetary benefit arising out of the claim of MACP and ACP to the petitioner,
Which has itself admitted by the respondent.
which stands admitted by the respondents, considering the aforesaid submissions and as per the counter affidavit filed by the respondents, supplementary counter affidavit filed by the respondents, a decision was already taken to grant ACP/MACP, but the decision itself, by taking into consideration the period of service, the past period of service, but the same was kept subject to LPA number 322 of 2013. A final order passed in the LPA along with an analogous cases has been placed before this court, which revealed that the LPA has been dismissed. In view of the aforesaid facts and circumstances, the entitlement of the petitioner of ACP and MACP with regard to, by taking into consideration the past period of service, is not in dispute. Accordingly, this writ petition is disposed of, directing the respondent number 2. Who will release it? Respondent number 2.
Yes.
Respondent number 2. Directing the respondent number 2 to pass appropriate order in connection with claim of the petitioner with respect to ACP/MACP by taking into consideration his past period of service and pass appropriate order for so that the monetary benefit arising out of the same is also remitted to the petitioner within a period of 3 months from the date of filing of a representation by the petitioner along with a copy of the records of this case. हो जाएगा?
Yes. Also, representation was given to Upayukt Ranchi, Deputy Commissioner Ranchi.
तो डिप्टी कमिश्नर को आप पार्टी कहाँ बनाए?
For respondent number 4.
तो उन्हीं को बोल देते हैं, तो रेस्पॉन्ड नंबर 4 कर दीजिए. Respondent number 4, before whom the petitioner had filed representation for his claim. ठीक है, लेकिन आप fresh representation. This writ petition is accordingly disposed.
Item 30, First Appeal 156 of 2024.
Please, Your Worship.
Yes.
This appeal is arising out of against the order dated 31st January 2024, Your Worship, passed in Manisood case number 1 of 2022.
FA number 156 of 2024. आप हैं?
Your Lordship.
Respondent number?
All the respondents.
All the respondents. We have filed wakalatnama.
Your Lordship.
Learned counsel for the parties are present. This appeal is admitted for final hearing. Is admitted. Let the records be called for from the concerned court. ये कमर्शियल सूट बोल के कैसे फाइल होता है?
कमर्शियल सूट वहाँ कमर्शियल कोड नहीं है, इसीलिए से कमर्शियल सूट आजकल रजिस्टर वैसे ही होता है, लेकिन एफसी के बोकारो में कमर्शियल कोड नहीं है।
नहीं, सबका दूसरा जगह जुरिस्डिक्शन है।
इसीलिए
नहीं, सूट कितना वैल्यू कितना था? सूट वैल्यू
32,05,035 rupees.
अभी तो फर्स्ट पेज में नीचे में लिखा है सूट वैल्यू एट 32,05,035. Second line from the bottom, first page, between judgment.
एक करोड़ से नीचे का जो सूट है ना, वो कमर्शियल कोर्ट में वहाँ फाइल नहीं होता।
दो कोर्ट है, कमर्शियल कोर्ट के भी दो हैं, एक करोड़ के नीचे और 1 करोड़ के ऊपर।
हाँ।
लेकिन शायद वहाँ पर है ही नहीं, इसीलिए तो हम देख रहे हैं। हमें भी लगा कि ऐसा क्यों हुआ, आज देख रहे थे जिसमें शायद उस समय वहाँ है।
उस समय मतलब ऐसे
जैसे रांची में there are two commercial courts.
हाँ।
One trying
1 करोड़ से कम वाले का अपील कहाँ फाइल होता है?
यही होता है,
फर्स्ट अपील।
कमर्शियल अपील।
1 करोड़ से कम वाले का कमर्शियल अपील तो वही नीचे एपिलेट कोर्ट में ही फाइल होता है,
होना चाहिए,
क्योंकि डिस्ट्रिक्ट जज को छोड़कर फिर कैसे ही यहाँ पर आएगा।
वैल्यूएशन भी
वैल्यूएशन अगर 1 करोड़ से ऊपर है तो कमर्शियल कोर्ट के पास जाता है, डिस्ट्रिक्ट जज के पास, और वो उसका अपील सीधे ओरिजिनल साइड में, अपील सीधे कमर्शियल कोर्ट एपिलेट जुरिस्डिक्शन में फाइल होता है। लेकिन जो 1 करोड़ से कम का वैल्यू,
1 करोड़ से कम का, जैसे हमारा वहाँ पर भी पिकुलियरी जुरिस्डिक्शन शायद 25 लाख तक का इसके पास है, ओरिजिनल जुरिस्डिक्शन
1 करोड़ से कम का है,
सिविल जज जूनियर डिवीजन
1 करोड़ से कम का है।
ये तो 1 करोड़ से कम का,
तो ये जो 1 करोड़ से कम का है उसका अपील कहाँ फाइल होता है?
दोनों का वहाँ पर कमर्शियल एपिलेट डिवीजन शायद नहीं बना है, शायद नहीं
बना है, मतलब लॉ कॉन्टेम्पलेट्स नहीं बना है बोलने से कैसे ही।
अगर स्टेट गवर्नमेंट अगर नोटिफाई नहीं करेगी, एक बार देखना पड़ेगा, शायद
ऐसा कोई ऑब्जेक्शन भी नहीं है।
ऐसा कोई ऑब्जेक्शन नहीं, क्योंकि
क्या ही दिमाग लगा।
हाँ,
तो वी डू नॉट नो वहाँ क्या प्रोसीजर है और कैसे क्या किया।
सभी डिस्ट्रिक्ट्स में
ठीक है, तो हाँ, इट इज एडमिटेड, वी आर कॉलिंग फॉर द रिकॉर्ड्स। कब करेंगे ये बता दीजिए बस। Post this case for final disposal on 18th of February. The supplementary cost list to be taken up at. क्या ही अर्जी है?
हमें जस्ट बिना नोटिस से क्लियर हो गए हैं।
तो बड़ी अच्छी बात है।
हाँ, अच्छी बात तो है।
तो फिर क्या कमर्शियल सूट में क्या ही करना है?
नहीं, रिकॉर्ड्स वगैरह हमको भी बनाना पड़ेगा। इसको
रिकॉर्ड्स जो आएगा वही रहेगा।
नहीं, उसके लिए नहीं, मेरे भी हमको भी
हाँ।
अप्रैल में लगा देते।
एक बार आने दीजिए, हम आपको टाइम दे देंगे, हमको याद है। रिकॉर्ड आ जाएगा, रिकॉर्ड पढ़ने के लिए हम आपको एक और डेट देते हैं।
नहीं, हम भी अपना
मंगा लीजिए, जिसने वकालतनामा दिया है वो रिकॉर्ड भी देगा।
अपीयरेंस दीजिए। For hearing under order 41 rule 11 item 15 second April 67 of 2021.
Yes.
Defendants are the appellants. Plaintiff has filed a suit for injunction.
Suit for?
Plaintiff has filed a suit for injunction that has been allowed. Against that, defendant has filed appeal that has been dismissed. Against that,
Suit was for permanent injunction?
Yes. Without prayer for declaration of title. Therefore, my lord, as per my opinion, my lord, there is a substantial question about that. If mere injunction suit is not maintainable in absence of prayer for declaration of title and possession. Tell my lord, kindly see the judgment of the landed trial court, my lord.
Just a moment. The title was disputed?
Yes. They have say, as per the plaintiff, they has purchased the land on the basis of registered sale deed of the year 2008. Defendant has filed a written statement stated that defendant has purchased the same land in the year 2006. But seller are different. Seller are two brothers. And kindly see the judgment, first page of the judgment of the title suit, my lord, relief has been mentioned. That a decree may be passed for permanent injunction against the defendant by restraining him not to disturb the peaceful and lawful possession of the plaintiff over the scheduled land. Only, no prayer has been made for declaration of title, my lord. And case of the defendant, my lord, mentioned in the internal page 4, my lord, para 3. Para 3, my lord, written statement filed by the defendant, my lord, mentioned. Internal page 4. Relevant portion mentioned in the page 5, my lord. On the middle portion, sale deed number 297/2006, dated 27/1/2006 has been mentioned, by which defendant had purchased the land.
What were the issues, friend?
Yes. Issues, my lord. Page, internal page 9, my lord. Whether the suit is maintainable in its present form in the relief claim, whether the plaintiff has valid cause of action for bringing this suit or not, whether the suit is barred by principle of estoppel, waiver and accusation, whether the suit is barred for misjoinder or non-joinder of necessary parties, whether the plaintiff has got any valid right, title and interest over the suit land, whether the plaintiff has possessory right over the suit property, whether the plaintiff is entitled for permanent injunction against the defendant at any cost, whether the plaintiff is entitled to any other relief or reliefs under any other law or equity. My lord, my argument is based on the judgment of the Honorable Supreme Court in exactly similar matter, my lord, in which also defendant has filed his claim that he has purchased the land through registered sale.
The possession of the plaintiff has been declared?
Possession, he has not claimed possession.
No, he has not claimed possession, but there was a dispute.
Dispute, yes, my lord, because rent receipt has been issued in the name of plaintiff and as well as in the name of defendant. Mutation order has been passed in the name of plaintiff as well as in the name of defendant. And there is a judgment of the Honorable Supreme Court.
Issue number, let me just see.
इसमें सेम मैटर है मतलब सिमिलर ऑब्जेक्शन दिया गया रिटन स्टेटमेंट में इसमें पैरा 1-2 में फैक्ट है 1-2 को फैक्ट को भी थोड़ा सा हम पढ़ देते हैं मालूम सिमिलर है
may be permitted to be minor. Plaintiff 1 and 2 claim to be the respective owners in possession of the same two sites, having purchased them under two registered sale deeds dated 9/12/68. Exhibit A1, A2 from Miniby. The plaintiff further claimed that the same two sites were mutated in their name in the municipal record. They alleged that on 3578, when they were digging trenches in the order to commence construction, the defendant interfered with the same work. The plaintiff therefore filed with original suit number 279 of 1985 principal distribution for a permanent injunction to restrain the defendant from interfering with their possession. Similar relief has been paid in this case also. The defendant raised the suit. He claimed that the suit property measuring 300 square feet in premises number such and such was purchased by him from K.B. Damodar Rao, brother of the plaintiff, Painter Rukmini under registered sale deed dated 7/11/1970, that he was put in possession of the suit property by Damodar Rao, that the suit property had been transferred to his name in the municipal record, that he applied for and obtained sanction of plan for construction of building thereon, and that he had also obtained a loan from the construction of the central government by mortgaging the said property according to him. When he commenced construction of the suit property, the plaintiffs tried to interfere with his possession and filed a false suit claiming to be in possession. Thereafter, para 8 minor. Trial court has allowed the suit minor. Para 8 minor.
Yes.
Para 8 minor. The trial court decreed the suit by judgment dated 31/12/1985, relying on the two sentence in favor of the plaintiff, the tax paid receipts, and the oral evidence. It held that plaintiff was in possession of the suit property from the date of purchase and the defendant had interfered with their possession. The defendant filed an appeal challenging the judgment and decree of the trial court before the additional district judge, Procedural. The first appellate court held that the defendant was in possession of the suit property and the plaintiff had not made out even prima facie either title or possession of the suit property. It was of the view that in the circumstances, a mere suit for injunction was not palatable, and at least when the defendant filed his written statement denying the title of the plaintiffs and setting up a clear and specific case of title himself, the plaintiff ought to have amended the plaint to convert the suit into one for declaration and injunction. Consequently, it allowed an appeal by judgment and decree dated 9/12/91 and dismissed the suit. Being agreed, the plaintiff filed second appeal. And here also same minor.
No, here there is a slight difference.
Yes.
Here, in this case, the first appellate court held
Yes.
that the defendant was in possession of it.
Yes.
In this case, in your case, the possession is with the plaintiff.
No, that has not been decided, my lord. Actually, my lord, rent receipt has been issued for both of them, my lord. That has not been decided.
It has not been, possession has not been decided.
Actual, nothing has been decided, my lord. Kindly see, every issue has been decided without properly.
No, that is a separate thing.
That is, my lord. I am going to, my lord.
In a circumstances where the plaintiff is in possession of the suit property,
yes,
then under such circumstances, why should he seek a declaration of his title
नहीं
to
prove
have an
possession
injunction?
prove नहीं हुआ है, my lord.
पोजीशन तो दोनों का फाइंडिंग है, पोजीशन का आप बोलते हैं पोजीशन नहीं प्रूव हुआ।
Prove नहीं हुआ है।
कैसे नहीं प्रूव हुआ? ये वाला ये क्या है? रोमन 6 का क्या फाइंडिंग?
मेरा तो कोई एविडेंस को देखा ही नहीं गया।
वो दूसरा बात है।
इसमें और एक चीज है, मान लो मेरा जो कहना है कि मेंटेनेबल ही नहीं है, एक बार फॉर्म लिया जाए उसके बाद मान लो।
हाँ ठीक।
इसके बाद हम लोग भी ऑब्जेक्शन किए, फिर भी वो अमेंडमेंट नहीं किए हैं। उसी को सुप्रीम कोर्ट भी बोले हैं, ऑनरेबल सुप्रीम कोर्ट बोले हैं, पैरा इसी को अफर्म किए जो लैंडेड अपीलेट कोर्ट का जजमेंट है उसी को अप्रूव किए हैं। पैरा 32 एंड 33। पैरा 32 देख लिया जाए, मान
पैरा 12 में देखिए।
पैरा 12
Roman 1 and Roman 2.
Yes. Where is the scope of suit provision injunction led to injury property? Whether on the facts and plaintiff ought to have filed a suit for declaration of title injunction, whether High Court in a second appeal under Section 100 CPC will examine the factual question of title, which is not the subject matter of any issue, and based on the finding thereof, reverse the decision of the first appellate court. What is the appropriate decision? Yes, ma'am. Therefore, my lord, फाइंडिंग ऑफ द ऑनरेबल सुप्रीम कोर्ट देख लिया जाए। अफर्म किए हैं जो अपीलेट कोर्ट का था कि अमेंडमेंट करना था, उसी को अफर्म किए हैं। पैरा 32 में आया है। ऑनरेबल सुप्रीम कोर्ट वही किए हैं कि अमेंडमेंट करना चाहिए था। जब रिटन स्टेटमेंट में आ गया कि सब्जेक्ट क्लाउड हो गया टाइटल पर, तब अमेंडमेंट करना चाहिए पैरा 32 में ऑफ द जजमेंट।
आप पैरा 13.13 और 13.1 ये भी तो पढ़ेंगे ना?
यस।
पढ़िए।
The general principle as to when a mere suit for permanent injunction will lie and when it is necessary to file a suit for declaration and or possession with injunction as a consequence of relief who are well settled, we may refer to them briefly. Where a plaintiff is in lawful or peaceful possession of a property and such possession interfered or threatened by the defendant, a suit for injunction situation will lie.
Yes.
Yes.
So
Where
therefore,
a plaintiff is
therefore,
lawful
in
or
the
peaceful possession of a property and such possession interfered or threatened by the defendant, a suit for an injunction situation will lie. Where title is not disputed, it is not a complete
no.
sentence.
It is not saying that title is not in dispute. It is only saying that the plaintiff is in possession of the
उसके
property.
बाद वाला पढ़ लिया जाए मैडम।
A person has a right.
Right to protect his possession, my lord.
Yes.
So right is
आगे,
attached
आगे।
to the ownership, my lord.
आगे पढ़िए।
In the any person who does not prove a better title, देख लिया जाए, better title by seeking a prohibited injunction, but a person is wrongful possession not entitled to an injunction against the rightful owner, my lord. Therefore, title is attached to the injunction, my lord.
13.2 पढ़िए।
Where the title of plaintiff is not disputed, but he is not in possession, his remedy is to file a suit for possession and seek in addition, if necessary, an injunction. A person out of possession cannot seek the relief of injunction simpliciter without claiming the relief of possession. Where the plaintiff is in possession but his title to the property is in dispute or under a cloud, or where the defendant asserts title thereto and there is also threat of disposition from the plaintiff will have to sue for declaration of title and the consequent relief of injunction. It is this point is matched with this case. Plaintiff will have to sue for declaration of title.
Second appeal number 67 of 2021. Heard the learned counsel for the appellant. The learned counsel for the appellant submits that the judgments passed by the court, by the two courts, reveal that the suit was filed only for injunction and the defendant had claimed title over the property by virtue of registered sale. He has submitted that even the plaintiff was claiming title by virtue of registered sale deed, though subsequent in point of time, but by a different vendor. The learned counsel submits that in such circumstances, the plaintiff, the defendant having claimed title on the basis of the registered sale deed, the plaintiff ought to have amended the plaint seeking declaration of title and possession. And therefore, the suit seeking, therefore the learned courts were not, the learned trial court was not justified in decreeing the suit for grant of permanent injunction. He has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2008 bracket close 4 SCC 594 and has referred to paragraph 13. है ना? And has submitted that the principles with regard to maintainability of suit for injunction simpliciter has been discussed, and in case of dispute of title, simpliciter injunction of simpliciter suit for injunction is not maintainable, at least against the true owner of the property. कहाँ substantial question of law नहीं किए? क्या चीज़ क्या फ्रेम करती है? Considering the aforesaid submissions, this appeal will be heard on the following substantial question of law. whether the suit simpliciter for permanent injunction was maintainable, they could be decreed by the learned court when both the parties claimed title over the property through registered sale deed, but through registered sale deed, but through different vendors. Shall we issue notice to the sole respondent?
Yes, ma'am.
Sole respondent for which requisites under registered cover as well as ordinary process to be filed by Monday. Let the records be called for from the concerned court. Pose this case on 25th of February in the supplementary cause list awaiting service today.
Appearance. Item 16, second appeal 203 of 2022.
Reversal. Appellants were the defendants in the partition suit. Partition suit was, in the partition suit, there were two prayers. First prayer was that to grant a preliminary decree for schedule B, C, D and properties. And second prayer was to declare the gift deed dated 15th of April 1998 executed by defendant number 6 and 7 in favor of defendant number 11 and 12 as null and void to the extent it exceeds the share of their share. Now plaintiff and defendant number 6 and 7, they are own three sisters. The suit which was filed, the partition suit was dismissed on all the issues. The learned trial court held that
what was the finding on the point of jointness?
So far jointness, the trial court recorded that they are all separate.
So therefore
there. And so far the second prayer was concerned. The court held that plaintiff failed to prove that defendant number 6 and 7, they have gifted the property to defendant number 11 and 12 exceeding their share. And also,
since there was no jointness of property, so therefore the gift was valid.
The trial court held that defendant number 6 and 7, they have validly executed the gift deed according to the share. And it also held that so far that relief is concerned, that relief is barred by law of limitation. Because gift deed was executed on 15th of April 1998. Suit was filed in the year 1994. This was the finding recorded by the trial. So issue number 5. The appellate court reversed this finding, issue number 5. The appellate court did not advocate the findings, the findings recorded by the trial court. The appellate court recorded another reasoning. Now the appellate court recorded a reasoning that the donors, they failed to establish that they have a right to gift the property. Now this, the right of the donors was never challenged by the plaintiff itself. Plaintiff is saying that they are my sisters, they have a right, but they have exceeded their right. The second ground which the appellate court taken, the appellate court relied upon a judgment of a Supreme Court.
Just a moment. Where is the appellate court's judgment? How many parties are there?
Many parties.
Where is the discussion by the appellate court
Yes.
regarding the
Yes.
trial court's finding?
Yes. come paragraph page paragraph 17 of the appellate court judgment. Issue number running page 71.
Yes.
May I read?
No, I just want to know the trial court's judgment has been considered or not considered?
Not considered. The findings which was recorded by the trial court had discussed the evidences of DW1 and DW2 and came to the conclusion that the defendant number 6 and 7, they have not gifted the property exceeding their sale. This finding was not met by the learned appellate court. The learned appellate court gave its own reasoning. First reasoning that the donors they have failed to establish that they have a right. This was never challenged by the plaintiff. Plaintiff is saying they are my sisters, they have a right, but they had exceeded their right. The second reasoning which the appellate court gave, he relied upon a judgment of a Supreme Court. In a Supreme Court, in a different facts, where a Karta gifted an ancestral property to a stranger, the Supreme Court held that it can only for a pious purpose. A Karta can gift the property, ancestral property, to a stranger for a pious purpose. But in this case,
Essay number 203 of 2022. Heard the learned counsel for the argument. The learned counsel has submitted that the partition suit number 77 of 1994 was dismissed and the gift deed, which was also the subject matter of the suit, was held to be valid. The appellate court has reversed the decree and the gift deed has been held to be null and void. यही है ना null and void का?
Gift deed not binding upon the plaintiff.
Has been held to be not binding upon the plaintiff, but by reversing the decree, the reasonings which were given by the learned trial court has not been considered in the appellate court's judgment. And therefore the appellate court has not followed the principles laid down under Order 41, Rule 31 of CPC. He submits that while reversing the decree, not only while reversing the decree, the appellate court was under a legal obligation to discuss the findings, discuss and consider the findings recorded by the trial court. Yeah?
Yes.
This appeal will be heard, is admitted to be heard on the following substantial question of law. Whether the appellate court's judgment is perverse on account of appellate court's judgment by reversing the decree is perverse on account of non-consideration of the reasonings given by the learned trial court while dismissing the partition suit, and whether on this count the matter is fit to be remitted to the learned appellate court for fresh consideration. यही है?
Yes.
उसके बाद issue notice to the
Contesting respondents are defendant number 1 to 4.
contesting नहीं चलेगा ना?
They are the plaintiffs.
आपको सबको notice करना पड़ेगा. जितने भी हैं.
They are pro forma.
सबको. ट्रायल कोर्ट में तो नोटिस हुआ था, appellate कोर्ट में भी हुआ था. प्रो फॉर्मा है तो को प्लेंटिफ थे क्या वो? को डिफेंडेंट थे.
Co-defendants.
सपोर्टिंग यू.
Supporting.
तो आप उनका वकालतनामा फाइल कर देंगे, बात हो जाएगा।
मतलब ठीक है,
सिर्फ ऑर्डिनरी प्रोसेस का नोटिस करें। लेट नोटिस बी इशूड टू ऑल द defendants, all the respondents by ordinary process, for which requisites be filed within a period of 2 weeks from today. Let the records be called for from the concerned court. Post this case on 11th of March 25 in the supplementary cause list, awaiting service report and the records from the court. इसको पेंडिंग रखने से क्या ही फायदा है?
For hearing item 17, second appeal 119 of 2017.
Yes, appellant. Yes, appellant. Mr. Ramchand Sahu. लास्ट चांस भी हो गया है इसमें। This appeal is already abated against respondent number 1. Where is the appellant? Nobody appears on behalf of the parties. Post tomorrow. Next.
Item 18, second appeal 152 of 2017.
Leadership, I'm not well versed with the facts of this case and I pray for you next.
That is not an excuse.
Last answer we got it.
Confused. Where is the respondent? Respondent has appeared. कोई है? लास्ट चांस ऑलरेडी हो चुका है, 1000 रुपये फाइन भी हो चुका है। 1000 के बाद अब कौन सा कितना जीरो लगाना है ये बताइए, और लास्ट चांस पे भी कल ही होगा, यहाँ पे ऐसे नहीं चलता। कितना जीरो लगा के कल का डेट किया बताइए। हाउ लॉन्ग हैव यू बीन प्रैक्टिसिंग?
This March, this is going to be 1 year.
सो यू आर वेल वर्स्ड। सब्सटैंशियल क्वेश्चन ऑफ लॉ पढ़िए और चालू हो जाइए। लाइए रिकॉर्ड दीजिए। यू डोंट हैव द फाइल। आपका क्लाइंट अगर ये सुन लेगा वीडियो रिकॉर्डिंग में तो आपके बारे में क्या ओपिनियन बनाएगा? अगला केस आपको देगा?
I'm appearing on behalf of Mr. Ravi Kumar Chaudhary.
अच्छा है, बहुत अच्छी बात है, उनको भी दूसरा केस नहीं मिलेगा। काउंसिल अपियरिंग विदाउट अ ब्रीफ इन सेकेंड अपील। हाँ,
Please grant me. I am assuring you I will prepare this case by tomorrow only.
हमारे कोर्ट में आपको बहस करने का मौका अब 6 महीने बाद ही मिलेगा। इसके पहले ही आई विल नॉट ग्रांट यू अपॉर्चुनिटी। आप टाइम मांगेंगे, हम तुरंत टाइम दे देंगे कॉस्ट लगा। जूनियर काउंसिल कैन नॉट से आई हैव नॉट रेड द ब्रीफ। ये कैसे हो सकता है?
Actually, I didn't read the file.
आपके सीनियर आपको फाइल नहीं देते पढ़ने के लिए?
देते हैं। हम रेगुलर नहीं है, मेरे जुडिशरी के एग्जाम्स हैं।
अच्छा होगा मेरे पास इंटरव्यू के लिए मत आ जाइए। हाँ, रेगुलर नहीं है आप, कैसे चलेगा? यू कैन हैव इट बोथ वेज ना। आप क्यों खड़े हो गए इनके समर्थन में?
Actually, my senior was told to take some Passover for short period.
वो टेकन फॉर ग्रांटेड। शॉर्ट पासओवर ना, पासओवर देंगे, एडजर्नमेंट नहीं देंगे, क्योंकि एक बार 1000 रुपये फाइन करके हो चुका है। इस बार 10,000 रुपये से कम फाइन नहीं होगा और कल का डेट पड़ेगा, इसीलिए आप एडजर्नमेंट मत कीजिए। पासओवर कर रहे हैं, 425 में कॉल आउट होगा। मैडम फाइल पढ़िए, ऐसे नहीं करिए, डोंट डू दैट।
Item 19, second bill 156 of 2017.
Yes.
Madam, substantial question of law has been framed by order dated 24/9/2018, madam.
Yes.
Has you also got the order?
Read the substantial question.
Yes. Whether the learned appellate court had failed to interpret Article 60 and 109 of the Indian Limitation Act as well as Section 8 of the Hindu Minority and Tradition Act in the correct perspective, as there was no partitions of the ancestral property belonging to the father of the creator, and further the sale deed under challenge did not obtain any permission from the court, which is the mandate of Section 8 of the Act of 1956. It's a reversible judgment, my lord. The plaintiff had.
Where is other side? They have appeared?
Yes, my lord. The other side has appeared.
You start. अभी आ जाएंगे वो, चिंता मत करो।
Yes, ma'am.
Let us see the trial court.
Yes, ma'am.
What was the case of the respective parties? Then we will see that what were the issues.
The trial court.
एकदम आराम से करने का है, कोई हड़बड़ी में दिमाग में मत रखिए। दूसरा कोर्ट में नहीं जाना है ना?
No.
चल।
Trial court judgment is page 10, madam.
Yes.
The suit is remanded back to this court by the learned appellate court, that is the additional district judge 10 Dharpad, provided his judgment and order dated 31/7/2004 in TA number 9 of 95 for framing two issues afresh as observed and directed by him. It is judgment by section aside. The judgment and decree passed by this court in TS numbers 174 of 88 dated 31/3/95 after fresh hearing to decide the suit. Para 2. The case of the plaintiff in brief is that the suit plot under Mauza Kanchanpur is situated under Khata number 38, plot number 1184, area 54 decimals, and originally
the suit property was recorded in the name of Tukhi Mato and his 4 brothers having equal shares therein. It is further pleaded that during the course of trial, the suit property was partitioned among the brothers, but at the same time it is pleaded in para 4 of the plaint that the recorded tenant, Kanhai, did not took his share in plot number 1164, while other brothers got their 1/4 share. As such, all the 4 brothers having 13.5 decimals of land. It is further pleaded that Tukhi Mato died leaving behind 3 sons, namely Hiralal, Govind and Jailal. As partition took place amongst Hiralal, Govind and Jailal. After partition, 13.6 decimals of the suit property became the exclusive share of Jailal. Subsequently, Jailal died leaving behind his only son Karmu and his wife Sonia. Thereafter, Karmu constructed a house on the western side of the suit plot, measuring 8 yards in length and 1 by 5 yard in breadth, with a kota on it, and lived it with his family and consisting of his 2 sons, Mangru and Badru, and his wife Sonia. Badru was the hardly aged 2 years when his father died, and plaintiff's mother Sonia died about 10 years ago. The plaintiff at present about 23 years old, that is his age of majority in 1986, and the plaintiff lives in a partition of the said suit that Mangru, his brother, also lives in the adjoining room. It is also pleaded that defendant number 1, in last week of November, threatened the plaintiff to hand over vacant possession of the house on the allegation that Mangru, the defendant number 2, has also sold his share in the land as well as the house to him.
टाइम नहीं मिलेगा।
नहीं 4 में वो बहस कर मिस्टर पीके मुखर्जी अभी लाइव इस केस में।
तो आप सुनिए, जो बहस कर रहे हैं आप सुनिए, फाइल का है, फाइल भी उन्हीं के पास है।
हाँ।
एक बहस में 2 फाइल रखते हैं।
नहीं वो पढ़े हुए वही है ना, वही उनको भेजे। वो 4 में बहस है, हियरिंग है वहाँ की, इसीलिए तुरंत तो होने तो कल सब
नहीं थोड़ा समझ रहे हैं,
ठीक
है, लेकिन आप जाइए मत। आज जब आप पास ओवर के लिए प्रेयर किए हैं, यहीं बैठिए,
ठीक,
सुनिए क्या बहस है, ठीक है। कोर्ट का क्वेरी उनको बोलिएगा, थोड़ा यूट्यूब में भी देखने, ठीक। यस।
Para 3, it was pleaded that defendant number 1 in the last week of November threatened the plaintiff to hand over vacant possession of the house on the allegation that Mangru, the defendant number 2, has sold his share in the land as well as the house to him as late as in March 1983. That the defendant number 1 has also disclosed that the plaintiff's mother, namely Sonia, during the minority of the plaintiff, has sold his share on 15/6/1973, and the plaintiff went to Dhanbad's registration office and made through search as to whether any such deed or deeds were executed in favor of the defendant number 1 by his mother or by brother. Para 4, it was further pleaded that on inquiry the plaintiff got certified copies of the deed on 2/12/1988, being sale deed number 526 dated 13/3/1973, alleged to be executed by Mangru Mato, defendant number 2, in favor of defendant number 1. And in the said deed of false recital was made that the plaintiff's brother, namely defendant number 2, was owner to the extent of 8 decimals of land of plot number 1184 of Khata number 38. And he purported to sell half of the room, so constructed on vacant land, giving a wrong boundary. That the recital of the sale deed does not show as to how Mangru Mato, defendant number 2, could get 8 decimals of land, when admittedly Karmu died leaving behind 3 heirs, namely his widow Sonia Mahatyan and 2 sons Mangru Mahato and plaintiff Bandhu Mahato. We stated that after partition in the manner stated above, Karmu had only 1/4 share of the total area of 54 decimals, that is to say 13.5 decimals of land. It is also pleaded that Mangru could have inherited only 4 and 5/16, although he purported to execute a sale deed of 8 decimals of land, and the plaintiff also came across a sale deed bearing number 14,222 purported to be examined, executed by Sonia Mahaten as guardian mother of minor Bandru Mato, the plaintiff. In sale deed also it is purported sale of 4 decimals of land with Khar. The plaintiff submits that the purported sale deed executed by his mother as guardian of the plaintiff should be set aside on the grounds, first, that the mother has no right to sell the property of minor even for legal necessity or for the benefits of minor without giving prior permission from the district judge. that the sale deed was without consideration as no consideration passed, that there was no necessity to share the share of the minor for his maintenance as Karmu left behind more than 10 bighas of land, that even the consideration amount as shown in the sale deed was absolutely low, inasmuch as 4 decimals of land on which Khar standing thereon could not have been sold for a mere sum of rupees 300, that the sale of undivided share is illegal and for so the residential house of the outsiders. Para 6. It was pleaded that the plaintiff submits that the purported sale deed did not and cannot confer any right on the defendants number 1, and defendant number 1 cannot ask for possession, and the plaintiff has attained his age of majority in the year 1986, and the present suit has been filed within 3 years from the date of attaining his age of majority, and the plaintiff submits that the plaintiff has now 50% of share in 13.5 decimal of land or plot number 1184 after the death of his mother, and by reason for the premises above said, the plaintiff is entitled to the relief. Para 7. It was pleaded for the purpose of the court fee and the jurisdiction. The suit is valued under relief first 300 rupees and relief for declaratory.
What was the relief?
Yes, madam.
What was the relief? What was the prayer in
Yes.
the suit?
The prayer has been in the plain manner.
They must have prayed for.
Yes. Yes, ma'am.
It is quoted.
It is, my lord, in the plate. It is A for cancellation of sale deed number 14,222.
It is quoted in the judgment.
Yes, ma'am.
Para number 9.
Para 9, my lord. It also pleaded that the plaintiff therefore praised judgments for cancellation of sale deed number 14,200 dated 15/6/1973 executed by plaintiff's mother to defendant number 1. B. For declaration of plaintiff's half share over an area of 8.14 decimals behind the western side of the plot number 1184 specifically and described in the schedule below. Para 6. For confirmation of possession alternatively.
This is a dwelling house
Yes, ma'am.
governed by Hindu law.
Yes, ma'am.
Governed by Hindu law.
Yes.
All are Hindus.
Yes, all Hindus. All Hindus.
What was the plea of the defendant?
Plea of the defendant, my lord. That it is barred by limitation, my lord.
One was barred by limitation. What is the mandatory provision of Order 5, Rule 6? What is that? CPC.
Yes, ma'am.
Order 5, Rule 6.
Order 5
This
Rule
is
6 of appearance of the
service of
defendant shall be
summons.
fixed with reference to the current bill.
Specific Relief Act. Para number 12.
Para 10 is the.
Para 12
Yes,
at
ma'am.
internal page 5.
Yes, ma'am.
The age of majority. It was denied that the plaintiff attained the age of majority in 1986. It is submitted that the plaintiff.
That is the
was
plea of the
aged-
defendant.
Yes.
Yes.
We'll find out now what is the plea of
Yes.
defendant.
Para 12, my lord, I read it.
Yes.
It was pleaded that the statements made in para 10 to 12 of the plaint are not correct and are denied. It is denied that the plaintiff is aged about 23 years on the date of the suit. It is also denied that the plaintiff attained his age of majority in 1986. It is submitted that the plaintiff was aged about 30 to 31 years on the date of the suit and he attained his majority about 13 years before the suit. Mangu has been living on the western side of the purchased land of this defendant in plot number 1184. The plaintiff had been living at village.
Let us see the issues.
Issues. Yes, ma'am. Issues is page 17, madam. Internal page 8. As a report. Issue number 1, whether suit is maintainable in the present form. 2, whether there is any valid cause of action for the present suit or not. 3, whether suit is barred by limitation. 4, whether plaintiff is entitled for a decree for cancellation of sale deed bearing number 14,222 dated 15/6/1973. 5, whether plaintiff is entitled to the other relief claimed in the suit. 6, whether plaintiff is entitled to any other form or any other or further relief. 7, whether Sonia was entitled to execute the sale deed for his minor son Bandhu Mathur without the permission of the court, and whether the sale deed executed
This
in
is
favor.
the central issue, issue number 7.
Yes, ma'am.
Let us see the finding with regard to
Finding,
issue
yes.
number 7.
That is at page 90, my lord.
Yes.
Issue number 4 and 7.
Yes. Read
May I
it,
be
please.
permitted to read?
Yes, please. Full text.
Since both the issues are correlated with each other, therefore they have been taken up together. On perusal of the case record, it appears that it is admitted by the main contesting defendant number 1, namely Hublal Mato in para 15 of his written statement, that Sania Mahatin, for herself and her minor son Bandhu, being in urgent necessity of fund for meeting necessity family expenses, sold 4 decimals of the land in plot number 1184, including the structure for the valuable consideration of the answering defendant, by a registered deed of sale dated 15/6/1973 in presence of Mangru Mato, brother of the plaintiff, and she put this defendant in possession of the same. On perusal of the case record, it also appears that the registered sale deed number 14,222 dated 15/6/1973, Exhibit C, goes to show that altogether 54 decimals of the suit land in plot number 1184 under Khata number 38 was sold out to defendant number 1, Hublal Mato, by Sonia Mahaten as guardian of his minor son. As such, it is admitted that by defendant number 1 in his written statement as well as in the recital of the registered sale deed as mentioned above, that the plaintiff was minor at the time of execution of the aforesaid sale deed, and Sonia Mahaten is acting as a guardian of his minor son Bandhu Mahato to execute a registered sale deed of the suit land, including the share of the plaintiff. On perusal of the case record, it also appears that the DW2 Hublal Mato, who is the main contesting defendant number 1, has also admitted that the fact in para 13 of his cross-examination dated 18/1/10 that when the land was purchased by him, no partition had taken place among them, and he had purchased the land from the joint property, and no suit was filed by him against other co-sharers for partition of the land. Secondly, in para 20 of his cross-examination, he has also admitted that fact that in the year 1973, before the purchasing of the land from Sonia Mahatin, no permission was obtained from the district and session judge. On perusal of the case record, it is also appears that DW5 Hublal Mato has also admitted the fact in his earlier disposition dated 25/94 in para 10 of his cross-examination that he got no paper to show that Sonia Mahatin had sold her share. He has further deposed in para 10 that Sonia has sold the land as the guardian, and he has further deposed in the same para that he had purchased 4 decimal of land as share of Bandhu Mahato from Sonia, for which no permission was taken from the judge. He has also admitted from the fact that the same para that he has no document to show that 8 decimal land was in the name of Mangru. Lastly, he has also admitted the fact that he has got no paper regarding payment of consideration amount for execution of sale deed of 4 decimals of land of the share of Bandhu by his mother Sonia. In this way, in the light of the pleadings of defendant number 1, as well as the light of the depositions of defendant number 1, Hublal Mato, as mentioned above, it is categorically admitted by defendant number 1 that 4 decimal land as share of the plaintiff was sold out by his guardian mother to him without obtaining prior permission from the learned district and section judge Dhanbad. As far as regarding necessity to sell the share of the plaintiff by his guardian mother, it is also mentioned in the sale deed exhibit C that it was sold out due to the necessity expenses. But it not comes within the purview of the legal necessity, as the plaintiff has also filed and relied upon the rulings reported in AIR 1985 Calcutta 66, in which it is clearly held and observed by the Honourable Court that alienation of property of a minor under Hindu law by de facto guardian of the minor without legal necessity is void ab initio, and Article 16 of Limitation Act is inapplicable. In this way, in the light of the aforesaid discussion, and in light of the observation made by the Honourable Court, as mentioned above, it is found and held that Sonia Mahatin was not entitled to execute the sale deed for his minor son Bandhu Mahato without obtaining a prior permission of the court. As such, the registered sale deed number 14,222 dated 15/6/1973, executed by Sonia Mahatin on behalf of his minor son Bandhu Mahato in favour of defendant number is void ab initio, and the plaintiff is also found entitled for a decree for cancellation of the aforesaid sale deed bearing number 40 such and such. In this way, both the issues are decided in favour of the plaintiff. On paragraph 25 also, my lord, if you will see that also. It is correct. Paragraph 25. Issues number 7 is also. On perusal of the case record, it appears in para 10 of the written statement. It is very well admitted by defendant number 1, Hublal Mato, that the property of Khata number such and such was never partitioned between the 5 brothers. Therefore, no question arises that the suit property had come in the exclusive share of Joylal. In this way, the father of the plaintiff. In this way, the issue is also decided in favour of the plaintiff.
What happened before the appellate court?
The appellate court judgment. Is that page 36, page 30 minus the finding?
13 are the points for consideration.
Yes.
Okay. And then
Starts from page 23.
page 30.
Yes, ma'am. Page 30.
Yes.
Very perfectly.
Yes, please.
Point number 1, 2, and 3. All three points have been taken up together for the sake of convenience as they are interrelated to each other. In the instant case, it is admitted that the suit plot pertaining to plot number 1184, Khata number 38 of Mauza Kachanpur was recorded in the name of Dukhi Mathur and his 4 brothers, which is also evident from Exhibit D. It is admitted by the party that there was partition among the 5 brothers. One of the brothers, namely
Pause
Kanai.
here for a moment. Is it so?
Yes, ma'am.
It is admitted that there was partition. Is it correctly recorded? It is also admitted by the parties that there was partition amongst 5 brothers, because the trial court has said that there was no partition. Is it an admitted fact?
Well, no, there was no partition.
Trial court held that there was no partition.
There was no partition. The appellate court is saying
appellate court is saying that it is an admitted fact.
there was no partition, my lord. As far as there was no partition between the brothers of the.
Anyways,
They divided among themselves, but admittedly there was no partition of the record. One, the brother, namely Kanai, did not take any share of the such plot. Hence, it was divided into 4 equal, each consisting of 13.5 decibel. Further case of the plaintiff is that Dukhi Mathur died leaving behind 3 sons, namely Hiru, Govinda, and Jailal. The fact is not denied by the defendant. Further case of plaintiff is that there was partition among the 3 brothers, Hiru, Govinda, and Jailal. The suit plot number measuring 13.5 decibel fell in exclusive share of Jailal only. Jailal died leaving behind his only son Karmu, and Karmu died leaving behind 2 sons, Plaintiff and Mangru, and a widow Sonia. Defendant in this pleading have denied that there was any partition between the 3 sons of Dukhi Mathur, and the said land fell in the exclusive share of Jailal. However, in the fact of the incident case, the court is not required to venture into the fact there was a partition or not between the 3 sons of Dukhi Mathur. Further case of the plaintiff is that Mangru, brother of the plaintiff, sold 8 decimals of the land in favor of the defendant number 1. Appellant white sale deed number such and such in excess of share. However, the sale deed had executed by Mangru Mathur in favor of defendant is not under challenge. Plaintiff has merely stated in his pleading that Mangru Mathur sold 8 decimals of land consisting of house in excess of his share. Further case of the plaintiff is that Sonia, as a guardian of plaintiff, Mangru Mathur sold 4 decimals of land in favor of defendant number 1. Appellant white stated such and such, without any legal necessity or for the benefit of the minor, without the permission of district judge. The sale of undivided share is illegal and most of the residential house to an outsider. The purported sale deed executed by Sonia Mahathan cannot confer any right on defendant number 1, appellant. Plaintiff attained his majority in the year 1986 and the present suit has been filed in the year 1988 within the period of limitation. It has therefore been prayed that the sale deed bearing numbers executed by plaintiff's mother in favor of defendant number 1, appellant exhibit C be cancelled and plaintiff half share over an area of 8.14 decimal of plot number such and such be declared. Learned counsel for the plaintiff relied on the decisions of Kali Charan Naskar versus Sudhi Chandra Naskar reported in AIR 1985 Kolkata page 66. In the said case, the Honorable Kolkata High Court has held that executed of sale deed, namely Baman Moni, was neither an actual guardian nor de facto guardian. Hence, the sale deed was void ab initio. The fact of the said case is entirely different from the fact of the instant case. As such, ratio laid down in this case is not applicable in the facts of the present case. In the present case, the sale deed was executed by natural guardian mother. The fact is not denied that in the executant, Sonia Mahathan was natural guardian of the plaintiff. PW1 Mangru Mathur has himself stated in the cross-examination that his mother is illiterate and his elder brother Mangru Mathur has read up to class 4. His mother earned her livelihood by working as a labor. At the time of his father's death, he was a minor and he was brought by his mother. Thus, it is evident from Sonia Mahathan was the natural guardian of the plaintiff and she was responsible for bringing up the plaintiff. Learned counsel for the plaintiff argued that the sale deed was executed in violation of Section 8 of the Hindu Minority and Guardianship Act as the sale deed was executed without permission of the court. Learned counsel further argued the recital of the sale deed shows that the sale deed was executed to meet the necessity expenses and for the special programs. Learned counsel further argues that the minor property cannot be only sold in the case of legal necessity. Learned counsel submitted that according to the Mullah's Hindu law, Legal necessity means cost of taking out probate or letters of administration or payment of areas of government revenue, decree of or rented, occurred due after the death of the deceased owner, etc. Necessary expenses does not constitute legal necessity, and therefore the sale deed executed by Sonia Mahathir in favor of defendant is void ab initio and is likely to be cancelled. Learned counsel further argued that even assuming for the sake of the argument that the suit was for cancellation of sale deed was barred by limitation under Article 60 of the Limitation Act, plaintiff is still entitled for his share in the suit property, and therefore plaintiff has made a prayer under relief P for declaration of his share over an area of 8.14 decimal under plot number such and such. Fail to understand that how half share of the plaintiff will be 8.14 decimal when it is the case of the plaintiff itself that Duki Manto, ancestor of the plaintiff, has only 13.5 decimal share in plot number such and such. Para 16. On the other hand, the learned counsel for the appellant argued that Section 8 of Hindu Minority and Guardianship Act empowered natural guardians to transfer the property of the minor, which are necessary or reasonable and proper for the benefit of the minor for the realization, protection, or benefit of the minor estate. Clause 3 of the Section 8 of the said Act says that any disposal of immovable property by a natural guardian in contravention of subsection 1 or subsection 2 is voidable at the instance of minor or any other person claiming under him. Learned counsel further says that before execution of sale deed, executant did not take previous permissions of the court. Learned counsel further argued that Article 60 of the Limitation Act will be applicable in the present case. According to Article 60 of the Limitation Act, period of limitation for setting aside or transfer of property made by the guardian of award by the ward who has attained majority is 3 years when the ward attains majority. It is the pleading of the plaintiff himself in para 11 of the plaintiff that he is now at the present age 23 and attained his age of maturity in 1986. The suit was filed in the year 1988. If the plaintiff was aged in 23 in 1988, he attained age of majority in the year 1983. The suit ought to have been filed within the period of 3 years from the age of the attaining his majority. The suit was filed in the year 1988, which is beyond the period of limitation. As such, the suit is not maintainable. Learned counsel for the appellant has relied in the decision of Narayan versus Baba Sahib and others reported in AIR 2016 Supreme Court 1666. In the said case, the suit was filed seeking the relief of partition and for declaration that the sale deed dated B21/1982 and 28/11/1988 executed by defendant number 2 in favor of the defendant number 1 are not binding and not to be set aside, and the same has also for recovery of possession and the suit scheduled property are for mesne property. The fact of this case was similar to the fact of the instant case. In the instant case, it was also held by the Honorable Apex Court that one, the transaction taken place in the name of the minor, which is in contravention of 1956 and which is not done for legal necessity, such transaction is voidable and unless such a transaction is sought to be impeached or set aside. The question of recovery or possession of the property does not arise. It is further held that a suit by a minor to set aside the alienation of his property by the guardian is governed by Article 60 of the Limitation Act. To impeach the transfer of immovable property by the guardian, the minor must file the suit within the prescribed period of 3 years after attaining majority. It was further held that the minor plaintiff challenged the transfer of an immovable property made by his guardian in contravention of Section 8(1)(2) of the 1956 Act, and who seeks possession of property can file the suit only within the limitation prescribed under Article 60 of the Act, and Article 109, 110 and 113 of the Act are not applicable to the fact of the case. Learned counsel therefore argued that from the own pleading of the plaintiff, it is clear that the suit was filed beyond the period of limitation prescribed in Article 60 of the Limitation Act, and in the fact of the case, Article 109, 110 and 113 are not applicable as held by the Honorable Supreme Court in the aforesaid judgment. In the instant case, the suit is definitely barred by limitation, by the law of limitation in view of the pleadings of the plaintiff himself. The sale deed was executed by the natural guardian mother who was responsible for bringing up for the plaintiff. The plea of the learned counsel for the respondent that in view of Section 109 of the period of limitation would be 12 years is not applicable in the facts of the present case. Article 109 of Limitation Act deals with alienation of the ancestral property by the father of the ward. In the instant case, alienation was by the mother of the plaintiff. Therefore, I am not convinced by the argument advanced on behalf of the counsel of the respondent. Para 17, in view of the aforesaid discussions, I am considered opinion that the suit of the plaintiff is barred by law of limitation. Accordingly, the point number 1 is decided against the plaintiff and in favor of the appellant. The sale deed bearing number such and such, dated such and such, is voidable at the instance of the plaintiff in view of section 8(3) of Hindu Minority and Guardianship Act. The sale deed can be declared void only at the instance of the plaintiff. Since the suit for cancellation of the sale deed was filed beyond the period of limitation, I am of the view that the said sale deed is valid in view of the discussions made above. Accordingly, point number 2 also decided against the plaintiff in view of the aforesaid finding is not entitled for the degree of cancellation and sale deed number such and such stated.
Now you tell us that for the purposes of selling the property of a minor, was there any requirement of
Yes,
the
ma'am. My
deputy
lord, may
commissioner?
see section 8.
Yes, sir. Section 8. Hindu adoption and main. Hindu adoption act कौन सा है?
Hindu Guardian
Hindu
Minority and
Minority
Guardianship
and
Act
Guardianship
1956, my lord. My lord, may see section 8.
If that is decided, the matter would end. So the issue would be whether the natural guardian could have sold the property
Without the permission of the
without the permission. Section?
Section 8, my lord. Power of natural guardian.
Section 8.
Has your lordship?
Yes.
Power of natural guardian first. The natural guardian of Hindu minor has power subject to the provisions of this section to all the acts which are necessary or reasonable and proper for the benefit of the minor or for the realization, protection or benefit of the minor issue. But the guardian can in no case bind the minor by a personal convenience. 2. The natural guardian shall not, without the previous permission of the court, A. Mortgage or charge or transfer by sale, gift, exchange or otherwise any part of the immovable property of the minor, or B. Lease any part of such property by term exceeding 5 years or a term exceeding more than 1 year beyond the date of which the minor will attain majority. 3. Any disposal of immovable property by a natural guardian in contravention of...
The appellate court has not dealt with it.
No. It has not dealt with it. It has said that as it is barred by the limitation, Article 16. And in my plaint also, my lord, I said that...
Kindly read para 18 of the appellate court statute.
Para 18, my lord, yes, my lord. Para 18, my lord. The sale deed bearing such and such, dated such and such, is voidable at the instance of the plaintiff in view of section 8(3) of Hindu Minority and
Guardianship. It is void
Guardianship.
ab initio. It is not voidable, it is void ab initio.
Void ab initio, yes.
No, legally it is void ab
Void ab
initio
initio, yes, ma'am.
in absence of the required permission.
Permission. Therefore, it's a wrong finding, my lord.
Any judgment on this?
Yes, my lord. Not in this point, my lord. So far as limitation is concerned with the appellate court has said. The Supreme Court has recently that, my lord, from the date of knowledge, the limitation applies.
What was the date of knowledge?
The date of knowledge, my lord will see the plaint of the plaint on the other. Para 13, my lord, may I be permitted to read para 13 of the plaint?
Yes, please.
The defendant number 1 in the last week of November threatened the plaintiff to hand over vacant possession of the house on the allegation that Mangru, the defendant number 2...
Plaintiff was in possession of the property?
Yes, ma'am. And repeatedly he was in possession of the property, and when they came and threatened that you should dispose
On the basis of that sale deed?
Yes, ma'am. The basis of the sale deed executed by his mother. So the limitation also does not... Article 16 also does not apply because from the date of knowledge.
What is the finding of the learned court with regard to limitation and the date of knowledge?
Yes.
Let us come to the specific finding in that connection.
Of the appellate court, ma'am?
Of the appellate.
Para 6, ma'am. It is above para 17, ma'am. Last para of para page 33.
Okay. Yes.
I'll read from last second para. It was further held that a suit of condemned minor said to set aside the alienation of property by his guardian is governed by Article 60 of the Limitation Act. To impeach the transfer of immovable property by guardian, the minor must file the suit within the prescribed period of 3 years after attaining majority.
Not after attaining majority. If he has knowledge, date of knowledge is important. It is covered by which article? आर्टिकल वो लिमिटेशन एक्ट दीजिए. आर्टिकल नंबर
Article 16. Who set aside has your lordship got it?
Yes.
Who set aside a transfer of property made by the guardian of a ward. A. By the ward who has attained majority 3 years when the ward attains majority. B. By the ward legal representative 1 when the ward dies within 3 years or from the date of attaining majority 3 years when the ward attains majority. 2. When the ward dies before attaining majority 3 years.
And the period of limitation begins when the ward attains majority.
Attains majority.
And 59 is talks about knowledge also.
Yes.
But this particular section is not talking about knowledge.
About knowledge. Yes.
This judgment
Yes, ma'am.
is referring to limitation. Is it talking about date of knowledge?
Yes, ma'am. It's a recent judgment of the Supreme Court.
Okay.
Yes. Para 9, ma'am. From para 9, having considered the judgment of the High Court in detail. Having considered the judgment and judgment of the High Court in detail, we are of the opinion that the findings of the High Court are primarily factual. The High Court seems to have carried out, have got carried away by the fact that the suit was filed 13 years after the execution of the sale. The question is whether the plaintiff had the knowledge of the execution of the sale. The High Court expected that the plaintiff must have given meticulous details of the fraud perpetuated in the plain
That
itself.
was in the context of Article 59 of the limitation.
Yes, ma'am.
This is not
60.
in the context of
Article 60. But the said sale was in the violation of Section 8 of the Guardianship Act because the permission which has been observed by the trial court, my lord.
What is the consequence of not seeking a permission?
Yes, my lord, we'll see.
Then if you want to succeed, then under such circumstances, you'll have to say that irrespective of execution of the sale deed, it is not binding on you. And therefore, you need not even pray for setting aside of the sale deed, although there was a prayer to that effect.
There was a prayer.
Then how do you deal with it? Because this is dealing with Article 59 of the limitation.
Because, my lord, as your lordship has rightly observed that the set
59 talks about date of knowledge.
yes, ma'am.
60 is not talking about
the date of knowledge. It doesn't talk about the date of knowledge. Does not deal with date of knowledge.
So, how do you overcome this?
Only my contention would rest only that section admittedly by the defendants also, your lordship, they have failed to show any transaction and they have also stated in their depositions before the trial court that there was no compliance of section 8.
You see, you have to first overcome the
First
point of
overcome the
limitation. Without overcoming the point of limitation, nothing can be seen.
And so far this judgment of the Honorable Supreme Court is considered to the Article 59 and not Article 60. because Article 60 does not speak about from the knowledge itself.
So,
And the substantial question has been framed on Article 60 and looking up.
$60 and $109.
109.
What is 109?
If the father by a Hindu governed by Mitakshara law to set aside his father's alienation of ancestral property 12 years. When the alienate take possession, but the appellate court said no, it was done by the mother. So this Article 109 won't be applicable. Though it was 12 years, the limitation is 12 years.
But what would be the consequence when the condition precedent for transfer by the guardian is not satisfied? Because there is no permission.
There was no permission admittedly.
So you have to find out something on this.
Maybe if tomorrow I'll find a judgment today.
They are also sitting there. आप सुन लिए? परमिशन नहीं है? 3 साल के बियॉन्ड फाइल हुआ है. ठीक है? तो पहले तो लिमिटेशन जब तक ये नहीं मीट करेंगे तब तक इनको किसी तरह का रिलीफ मिल नहीं सकता है. लिमिटेशन एक्ट में दिया हुआ है कि फ्रॉम द डेट ऑफ अटेनिंग मेजॉरिटी 3 years from the date of attaining majority. The age of attaining majority, is there any concurrent finding with regard to that? What is the date of attaining majority?
1983.
1983 by both the courts?
Yes.
Is it 1983 by both the courts?
I just it is a pleading of the council, my lord. In page 33.
Pleading will not decide.
Yes.
Is it an
Therefore,
admitted
yes.
fact?
No, my lord, I'm just saying that it has been only pleaded, not with the finding. Not the finding. It is only the pleading. The appellate court, while reversing, has not given any finding on the age. In the appellate court, it has not been given. It starts from the list, second last paragraph, page 33. Doesn't be to page 33, para 80.
Okay, let's. The arguments have remained inconclusive. Appearance record करें. आप अपना appearance दीजिए. Post this case for further arguments tomorrow. कल 10:30 बजे सुनेंगे.
Mobilize.
Question number 33. The first is only question is that whether the proceeding of land acquisition has been lapsed under section 24 for part payment or non-payment. वही मुझे देखिए.
Possession किसका पास है?
33.
Possession.
Possession तो ले लिया हमसे, पैसा भी दिया.
तो लैप्स कैसे करेगा?
क्वेश्चन है कि पेमेंट पार्ट पेमेंट.
पार्ट पेमेंट होने से लैप्स तो नहीं करता.
सुप्रीम कोर्ट का जजमेंट है.
कौन सा जजमेंट?
दो जजमेंट है. पुना म्यूनिसिपल कॉर्पोरेशन का, एक और उसके बाद का है उसका. तो वही पॉइंट है, जो कभी फाइनल डिस्पोजल इट विल हार्डली टेक 15 मिनट्स.
अदर साइड
हमारा साइड स्टेट के तरफ कभी भी रहने दे.
पार्ट पेमेंट पे लैप्स करता है. पेमेंट जमा हो गया होगा.
पेमेंट नहीं हमको दिया है पार्ट पेमेंट. दैट इज एन एडमिटेड पोजीशन. Admittedly, the part payment has been made. Therefore, reference was made by the district land acquisition officer to the special court at Hazaribagh. स्पेशल कोर्ट हेड दैट प्रोसीडिंग इज नॉट मेंटेन, बस उसी के अगेंस्ट मेरिट में नहीं. If it is not maintainable, then only that I could have been relegated to the original LA Act 1894. That has not been done. That only this is the order to be filed.
जजमेंट लेके आइए,
Judgment.
कल जजमेंट दे दीजिए आपको, और डेट आप
एडवांस में मुझे कुछ
एडवांस में जजमेंट कब तक देंगे बताइए.
कल दे देंगे तो नेक्स्ट वीक में जैसे आज ही के दिन में
ठीक,
उसको अगर फाइनल डिस्पोज हम कल दे देंगे.
कौन सा सीरियल नंबर कौन सा है?
33
33.
20 तक हो चुका है.
इसको फाइनल डिस्पोजल में डाल दीजिए. Learned आप अपीलांट हैं? आप अपीलांट हैं? Learned counsel for the appellant is present. He submits that a short point is involved in this case. As to whether the land acquisition proceeding under the 1894 Act lapsed on account of part payment of the compensation amount.
Yes. On promulgation of the new Act 2013. Right.
Upon coming into force of the new Act of 2013. देखिए आपका रिकॉर्ड नहीं देखे हैं, हम लिखा दिए हैं इतना.
गलत नहीं बोलेंगे, जो वही फैक्ट पार्ट पेमेंट.
Records आ गया इसका?
Yes. Record आया हुआ है.
Records have already been received. Post this case for final disposal on next, आज Wednesday है, on next Wednesday.
My lord, I have
In supplementary cost list.
And provide the
taken up at
photocopies yesterday.
कल नहीं करिएगा तो अगला दिन नहीं करेंगे.
कल दे देंगे.
आपका पास ओवर मैटर है, एक उनका पास ओवर है.
But I made an incorrect submission.
क्या?
वो एक कमर्शियल सूट और कमर्शियल ये का जो बात कर रहे थे जिसको एडमिट किए, एक्चुअली जजमेंट में कमर्शियल कोर्ट नहीं था, लेकिन डिक्री में हम देखें कमर्शियल कोर्ट है. Therefore the effect would be that it would be a commercial appeal under 13(1) or 13(1)(a). That is the problem. इसको लगा
नहीं,
सकते.
प्रॉब्लम है आपको हम बता रहे हैं. There is an issue on this. वहाँ का अपील तो जाएगा एपेलेट कोर्ट के पास.
तो कमर्शियल एपेलेट कोर्ट वहाँ है नहीं.
वहाँ है, सब जगह है. कमर्शियल एपेलेट कोर्ट होगा सब जगह. जहाँ कमर्शियल कोर्ट कॉन्स्टिट्यूट हुआ है वहाँ कमर्शियल एपेलेट कोर्ट भी कॉन्स्टिट्यूट हुआ है.
लेकिन जहाँ पर कि अपील का वैल्यू, सूट का वैल्यू 25 lakhs से ऊपर होगा, वो इधर है.
कमर्शियल कोर्ट के पास जाएगा 25 लाख का.
कमर्शियल एपेलेट डिवीजन.
कमर्शियल
एक बार
ओरिजिनल को
आपको लगता है कि अगर इसको अगर कल रख दें या ये कर दें तो थोड़ा उसका सबमिशन कर दें.
उसमें कमर्शियल कोर्ट लिखा हुआ है.
वहाँ पर 13 में एक
कौन सा सीरियल नंबर कौन सा है?
सीरियल नंबर है 13.
अपीलेंट कौन थे? आई थिंक वो मिस्टर पांडे नीरज राय के जूनियर थे, है ना? हमको याद है मिस्टर पांडे नीरज राय के जूनियर थे. ठीक है, उसको नेक्स्ट वेडनेसडे को ही रखना पड़ेगा.
तो उस पॉइंट में गलत ना हो जाए.
हाँ, नहीं गलत हो जाएगा ना. ये हमारा ऑफिस भी नहीं पॉइंट आउट करता है. इसको ना जरा रिकॉर्ड स्टैम्प रिपोर्टर को जरा दिखाइए और देखिए कि पूछिए उससे कि ये जो है मैटर जो है डीबी में जाएगा कि सिंगल में जाएगा, है ना? थोड़ा सा उसको बुला के पूछिए. फाइल
गलती
नेक्स्ट वेडनेसडे को वो पुराना ऑर्डर रिकॉल उनको खबर कर देंगे.
हम बोल देंगे
नेक्स्ट वेडनेसडे को सप्लीमेंट्री में डाल.
हाँ ठीक है. इस बीच में अगर वहाँ स्टैम्प रिपोर्टर से दिक्कत क्या है,
हम तो उसको बुला के ही समझते हैं.
ठीक है.
क्योंकि क्या है, छोटी छोटी चीजें हैं, गलत हो जाएंगी तो बहुत ज्यादा
दिक्कत हो सकती है. जजमेंट में नहीं लिखा है कमर्शियल कोर्ट, लेकिन डिक्री में लिखा है, तो उन्होंने शायद ये गलती की होगी.
हो सकता है. सूट वैल्यूएशन से ही पता लग जाएगा.
हाँ
ठीक. ये क्या है? ये पास ओवर है आपका. हाँ, आपकी जूनियर को थोड़ा डांटे, फाइल नहीं पड़ती. तो क्या करना बताइए?
कोई डेट फिक्स कर देगा फाइनल डिस्प्ले होने.
आपका तो डेट तो आज ही के लिए फिक्स था ना.
आज फिक्स नहीं.
आप 1000 रुपए तो पहले फाइन दिए हुए हैं.
फिक्स
उसके
नहीं
पहले लास्ट चांस हुआ है.
आज उसकी लास्ट आवर में
देखिए फिक्स तो हो नहीं सकता ना, यहाँ लिस्ट
या इसी वेडनेसडे को रहेगा, हम कर देंगे. आई एम नॉट टेकिंग
आई वाज ऑर्डर मत ड्रॉ करिए, इसको खाली ऐसे ही पास ओवर करिए.
यस,
ऑर्डर ड्रॉ करने से तो फिर फाइन लगाना.
नहीं ठीक
है. मैडम को बोलिए तैयार होने. आप लोग तो बिजी रहते हैं दूसरा कोर्ट में. ठीक है.